Well, Dave, it's very intimidating following Michael McCulloch because he is, it's like going from the sublime to the ridiculous kind of. Michael gave a very carefully worded, compelling presentation. Well, relaxed, because mine is neither of those things. And one good thing is that almost half this audience are McCulloch children, so I feel like I can, just exaggerate. It's always slightly, but so I feel like I feel at home. I'm just
and future adoptees.
That's right. Say anything, and it's like the key thing, of course, at this event is the free coffee and donuts, and they got the chocolate-covered donuts, which is unbelievable. I can't say it's a healthy choice, but it's it's a very gratifying one. On a cold winter's morning, you got up early probably to get to this. So I'm my hook or whatever my pretext for being here is that last Friday, I guess, I filed an amicus brief at the Supreme Court. This is it. I mean, in all its glory. One nice thing about this brief is it really is brief. That is, it's less than 10 pages, and in my old age, I just realized we have limited time, and so therefore, the shorter the better in principle. I haven't got it down to a tweet yet, but I'm working on that. So I filed this in a case out of California from the Ninth Circuit Federal Appeals Court. The case is called National Institute of Family Life Advocates, or NIFLA, versus Xavier Becerra, Attorney General of the state of California. And the case involves a First Amendment challenge to a California law that basically requires crisis pregnancy centers to advertise for abortions. And the way the law is written, essentially, any facility that already provides or refers for abortions is exempted from this law. So it has the effect of only being a one-sided rule that only requires pro-life entities actually to advertise for abortions, right? And there doesn't seem to be any corresponding obligation on the part of abortion clinics to advertise about pro-life alternatives, right? In any case, the Federal Appeals Court in California affirmed the decision of the Federal District Court in California upholding this law when faced with this First Amendment challenge. The First Amendment challenge is actually pretty simple. It's that the First Amendment freedom of speech entails the freedom not to speak, right? And therefore, these crisis pregnancy centers basically have the right not to refer for abortions, not to advertise for abortions. And our brief really develops in kind of legalese this argument, and I filed it on behalf of Mass Citizens for Life, which you all know. Jan Fox is our distinguished president, and also Eleanor McCulloch, who is well known in legal circles because she was the lead plaintiff in the case of McCulloch versus Coakley that just a few years back, a case at the Supreme Court that struck down the buffer zone law in front of abortion clinics in Massachusetts. Now, one of the interesting things about that case, it was a unanimous First Amendment decision, but there was a price to be paid for the unanimity in the sense that in order to get the likes of Ruth Bader Ginsburg to join in the opinion, essentially, Chief Justice Roberts had to limit the holding, so it really, in effect, applies pretty much only to the Massachusetts buffer zone and, law. And so one of the things I'm hoping for actually in this case, I think we're going to win at the Supreme Court, and I think we can win 5-4. Obviously Kennedy being the swing vote as usual. Talk about usual suspects. But the dynamic of the court has changed significantly, I would say, since the death of Justice Scalia and the appointment of Justice Gorsuch. One thing that's changed that's very significant, I think, is that Gorsuch is a friend of Justice Kennedy and clerked for him on the Supreme Court. And Gorsuch, I think, is going to be solid on this issue and all pro-life issues. But furthermore, I think he'll be able to bring Justice Kennedy along in a way that Scalia never was able to, because Justice Scalia, bless his soul, he's a wonderful figure, actually, the best writer that the court has ever had. That's really saying something. But he also tended to burn his bridges with the opposition, right? And so he loved kind of making fun of, judicially and otherwise, the opinions of Justice, in particular, Justice Anthony Kennedy and Sandra Day O'Connor when she was the terminal swing vote, So I guess I'm saying I think we're going to win 5-4, and even though in general I prefer unanimous decisions of the Supreme Court, in this case I'm actually preferring a 5-4 decision because I think that would mean that it will be a broader holding that will be applicable in a number of other contexts and not simply striking down this California law. I think the California law is particularly outrageous and grievous. But there are all kinds of similar situations. The government is trying to force people of conscience to say things that they fundamentally disagree with, right? I mean, they're doing it in the assisted suicide area. They were doing that with, abortifacient contraceptives under the Obamacare contraceptive mandate. And this is a recurring issue, right? So it would be nice to have a relatively broad holding that would, in effect, clear the field of this kind of illiberal legislation, right? That is requiring people to violate the Constitution. There is another case before the Supreme Court this term, the Masterpiece Cake case, the big gay wedding cake case at Colorado. I'm actually less optimistic about the result there, although on the basis of the oral argument, it looks like the freedom of speech challenge is going to win. And again, it's an argument against compelled speech, right? But viewing a wedding cake as some form of expression, right? I think that's a closer case in a way, and I think Kennedy's vote is less reliable in that context than in this context. So we'll see. But in both cases, I mean, and the reason I kind of got into this compelled speech issue, I first got into it really 23 years ago, in 1995, I guess, yeah, 1995, in the St. Patrick's Day parade case out of South Boston, where Massachusetts courts were saying that in the St. Patrick's Day parade had to include a gay, lesbian pride contingent because otherwise it was discriminating on the basis of sexual orientation in a place of public accommodation, which was a violation of Massachusetts civil rights. We claimed, although this claim was not successful in any of the Massachusetts courts, the only person who accepted this argument actually was Justice Joe Nolan on the Supreme Court, who wrote a famous dissent at the Massachusetts Supreme Court level. We were claiming that essentially to require the inclusion of a gay pride parade in a privately organized St. Patrick's Day parade violated freedom of speech and of association of the parade organizers. In this case, it was Wacko, Hurley, and it's probably the only Supreme Court case which has the name Wacko in it. It was also probably the first Supreme Court case that had the words lesbian and bisexual in its title, at dubious distinction. In any case, the U.S. Supreme Court gave us a unanimous First Amendment decision, which is kind of a landmark decision. It's the leading parade case, really, in Supreme Court history, that this did violate freedom of speech and freedom of association, in particular, this form of compelled speech. And so in the Masterpiece Cake case, turns out when the Solicitor General filed a brief in support of the baker who was being brought up on violations of civil rights charges in Colorado, the U.S. government's, the Solicitor General's brief basically relied principally on the Hurley case, the St. Patrick's Day parade case, in arguing against this form of compelled speech, right? So I guess what I'm saying is I'm into this compelled speech argument. I have been for a while, because I wrote the briefs on behalf of Wacko, Hurley and Company. This is my one legal claim to fame. You know, it's less than 15 minutes, actually. You know, it's like ancient history now. But it turns out this case is, this case is in all the constitutional law books, except the one I'm using this year in my, my constitutional law course, because I stupidly didn't look to see if it was, covering my case. And I should say about this brief, I mean, I filed on behalf of Masses Elderly McCullough Expectant Mother Care, which is this network of New York City crisis pregnancy centers that is run by an old friend of mine, Chris Slattery, who is this incredibly intrepid pro-lifer. I mean, that he's been in and out of jail, fines, civil and criminal cases are an ongoing feature of his life. But I'm saying he's heroic, in effect, in offering women alternatives to abortion, right? In the devil's den of New York City, as much as I love New York City. And the final Amicus is the pro-life legal defense fund, on which I sat on the board of directors for a number of years, but now I'm on the board of advisors, and instead Mark Bradley, who's a student of mine, is now on the board, who's here at his first March, actually. He's now on the board of directors. So those are, and my co-counsel in filing this brief was none other than the great Professor Mary Ann Glendon of Harvard Law School. And I guess I say the best for last, because I'm not going to rehearse the legal arguments. This brief was really totally researched and written by a group of 9 pro-life Harvard Law students over Christmas break. That is, they got out of their final exams on December 19th or whatever, and just worked on this for the next couple of weeks, in Canada. And they wrote it. And of course, I signed it and filed it, I'm the Supreme Court bar, and I kind of know how you do these things, You've got the pro-life legal defense fund to pay for the printing costs and the mailing costs and whatever, the certain stuff, kind of legal red tape that you have to do. But I'm saying, I could submit this to the print of this, Bateman and Slade, the Supreme Court printer, in Boston. I didn't have to change a comma in the thing, right? So in other words, my contribution was 0 to the brief, right? This is a group of Harvard Law students, assembled by Stephen Obiajulo, who's a 3L, and coordinated by a 2L named Grant Newman. And so, law professors are great at taking credit for other people's work. But I just want you to know that actually this was their work, and it's something I'm extremely proud that these kids, did this. I mean, I think it's, my hope is the younger generation. I mean, as I go to a number of these pro-life marches over the years, I mean, the average age just seems to drop every year, right? I mean, I think I was the first one in January 1974, right? And there was a lot of old church ladies and people, fogies, I mean, in the good, but I'm saying now it's just crowded gangs of teenagers or younger, right? I mean, witness the McCullough children, who I wouldn't want to mess with. I mean, so anyway, I think that's pretty much all I want to say. I mean, I've worn out my welcome. Please get your donuts. I mean, coffee. Yes.
Dwight, I've heard about the blue slip and the Ninth Circuit, the First Circuit, that U.S. senators approve certain people for judges.
Oh, yeah.
Do you think they'll do away with that so we can have some conservative judges in the Ninth District and the First District in the future?
Yeah, I don't know about the specifics of the procedure. My sense of it is that, in fact, the Senate has been approving Trump's nominees, beginning with obviously Justice Gorsuch, which I think is a wonder. to me, that's the one thing that he's done that is terrific. I mean, he's been, in general, Trump, for all his kind of reckless, craziness, I guess. His judicial appointments have been really quite good in general, right? And they've been confirmed by the Congress. Yeah.
Well, from what I've heard, I guess, is that a lot of judges in lower courts that are around 30 years old or so.
Yeah, no, I think that's right.
Because he's looking to elongate, because these people are going to be on their benches, on the bench for the next 10, 20, 30, 40 years.
Right.
Making outlasting career politicians.
No, I think that's right. I mean, one of the things that's an interesting consideration working with this group of very talented Harvard Law students on this brief is I've been talking to them about, to what extent they want to be publicly identified with this cause, in their resumes, because these people could be Supreme Court law clerks, federal judges, and actually being associated with this kind of controversial issue, as crazy as it is, it may in fact impede their ability to rise in the current climate. So it's not, it's a little bit of a tricky calculus, right? But anyway, yes.
Have you been following what's been going on in Hartford, Connecticut with the city council?
Not really, although don't they have something similar to this kind of?
Yeah, they passed an ordinance somehow compelling birthright-type clinics
Yes.
to disclose that they are not really clinics.
Or that they're not licensed. Actually, there's another provision of the California law that does that as well, right? So that provision is also under legal challenge.
Yeah.
So we'll have to see how that fares at the Supreme Court. But I think those kind of regulations will depend on the outcome of this case.
Yeah. That's great.
Yeah, thank you. By the way, I see Tom Harvey is here, and Tom Harvey is a hero. I mean, hometown hero. So I mean, he organized the attempt for the referendum that came close, but not quite close, to cut off funds for abortion in Massachusetts, right? This recent. So, okay, I mean, thank you for listening to me.
Trying it again in 2019.
What's that? Trying again? 2019.